So once again, good day everyone. This recorded discussion will talk and explain further the Article 1338 to 1355, which is the continuation of Chapter 2. So let's begin. Article 1338 states that there is fraud when, through insidious words or machinations of one of the contracting parties, the other is induced to enter into a contract which, without them, he would not have agreed to. So there are two kinds of fraud. First is the causal fraud or dolo casante, which is defined as the fraud employed by one party prior to or simultaneous with the creation of the contract to secure the consent of the other. It is the fraud used by a party to induce the other to enter into a contract without which the latter would not have agreed to, taking into account the circumstances of the case. And the second one is incidental fraud or dolo incidente. It is the fraud that does not have a decisive influence. By itself, this fraud cannot cause the giving of consent, but only refers to some particular or accident of the person employing it to pay damages. It is a fraud committed at the time of the performance of the obligation or after the valid contract has been entered to. Actually, we already discussed the incidental fraud and abdication specifically in Article 1170, but we still need to differentiate for the sake of clarity. So here, in the celebration of the contract, we have these two, causal fraud or dolo casante and incidental fraud or dolo incident. And now, we have this question. How causal fraud committed? Causal fraud may be committed through insidious words or machinations or by concealment. But concealment will be discussed in Article 1339. Insidious words or machinations include false promises, exaggerated expectations or benefits, abuse of confidence, fictitious names, qualities or power, in fine the thousand forms of fraud, which can deceive a contracting party, producing a vitiated consent. And it is not necessary that they constitute estafa or partake of any other criminal act subject to the penal law. In order that fraud may vitiate consent and be a cause for the annulment of a contract, the following requisites must be present. First, there must be a misrepresentation or concealment by a party prior to or simultaneous to the consent or creation of the contract. Second, it must be serious. Third, it must have been employed by only one of the contracting parties. Fraud committed by a third person does not vitiate consent unless it was practiced on connivance with or at least with the knowledge of the favored contracting party. So, if the two parties committed fraud, then the contract will remain valid. On the other hand, fraud committed by a third person does not vitiate consent unless the favored party was willing to be involved in it. The fourth one, it must be made in bad faith or with intent to deceive the other contracting party who had no knowledge of the fraud. If your action is in good faith, or in other words, you really thought that it was good and usually had no intention of doing the fraud, then it is not considered a fraud. The fifth one, it must have induced the consent of the other contracting parties. And last, it must be alleged and proved by clear and convincing evidence, and not merely by a preponderance thereof. So we have an example for us to better understand the causal fraud. Sonia offered to sell to Bea a ring, claiming that the stone on the ring is a diamond. Sonia knows that it is not a diamond but an ordinary glass. That's why, if Bea buys a ring, lying on the truth of misrepresentation of Sonia, then the sale may be annulled on the ground of fraud. So we have a second example. Peter sold to Vaughn a house and lot. misrepresenting that the place was accessible to means of transportation. The sale is voidable on the ground of fraud if Vaughn was induced to give his consent because of the representation. But if Vaughn purchased the property without any inducement from Peter, his mistaken belief that it was accessible does not vitiate consent, because the error refers merely to an incidental quality or condition of the thing. Next is Article 1339. Failure to disclose facts when there is a duty to reveal them, as when the parties are bound by confidential relations, constitute fraud. So Article 1339 is all about fraud, or simply in Filipino, panloloko. So first, let us define what is fraud. So fraud is a crime of using dishonest methods to take something valuable to another person, so when there is duty to reveal facts at hindi mo sinabi, bagkus ay inilihim mo pa, then that constitutes fraud. Fraud by concealment is defined as a neglect or failure to communicate that which a party to a contract knows and ought to communicate constitutes concealment. Yung concealment naman ay hiding something or keeping something secret. In this case, concealment is equivalent to misrepresentation. Silence or concealment by itself does not constitute fraud. The concealment contemplated in Article 1339 presupposes a purpose or design to hide facts which the other party ought to know. Sinasabi dito na ang concealment ay kaparehas sa pagsisinungaling, dahil kapag nagsinungaling ka to the other party at siya ay may karapatan na malaman yon, then that constitute concealment. Article 1339 provides for an example kung kailan mo masasabi that there is a duty to reveal facts and when the parties are bound with confidential relations, and the best example for that is partnership. So we have an example. Sam and Yum are partners engaged in the real estate business. Here, the parties are bound by confidential relations. Sam learned that Carlo was interested in buying a certain parcel of land owned by the partnership even for a high price. Without informing Yum, Sam was able to make Yum sell to him, refers to Sam, Yum shares in the partnership. Then Sam sold the land at a big profit. In this case, Sam is guilty of fraudulent concealment because he was under the duty to make disclosure of facts having a bearing the value of the interests of Yum in the partnership which were not known to Yum. But if the case is unintentional, the basis of the action is hindi maituturing na fraud, kundi mistake or error lang. If the sale was at the initiative of Yum, and Sam unintentionally failed to inform Yum of Carlos' offer, then the cause for annulment is mistake or error on the part of Yum. So, to summarize Article 1339, if you are bound to a confidential relation or partnership, at naglihim ka, sinungaling o hindi ka nagsabi sa partner mo, then that constitute fraud or panloloko. Article 1340. The usual exaggerations in trade when the other party had an opportunity to know the facts are not in themselves fraudulent. So this article is about the usual or tolerant exaggerations in trade. Usual exaggerations in trade or business known as tolerated fraud are not fraudulent by themselves when the other party has the opportunity to investigate and know the true fact. It refers to misrepresentation of traders tending to minimize the perceived effects of the thing or service advertised for sale. Hence, they are tolerated for still being bearable and excusable as long as they do not pass beyond the line of tolerance. This article gives allowance for the usual exaggerations of advertisement and at the same time cautions for the vendees and purchaser to use their common sense to know what they are negotiating with. The first paragraph stresses the rule of caveat emptor, meaning let the buyer beware. A buyer must be always on his guard dahil nga mako-consider lang na natural sa mga merchants and traders na maging exaggerated para kumita. In effect, the law does not consider such exaggerations, even if known as false by the party making them, as amounting to fraud that will affect the validity of a contract. Ang batas daw ay hindi kunikonsider ang mga exaggerations bilang fraudulent, kaya dapat as customer, they are expected to know how to take care of their concerns and to rely on their own independent judgment. Dealer stock or trader stock are defined as the representation which do not appear in the face of the contract, and these do not bind either party. So, we have an example for expressions or advertisement na kung saan ang mga ito ay dinabago sa atin, lalong-lalo na yung mga produktong pampapayat at pampapaputi na lagi nilang sinasabi na our product is the best and first in quality kahit naman mas maganda at epektibo pa sa iba. So, ang ekspresyong nabanggit ay hindi na bago pa sa ating pandinig. So, any person who relies on said exaggerations thus sow at his own peril. So, another situational example for this is Chu sold her land with an area of 60 hectares. By representation, he led Ardante to believe that the said land contained 98 hectares and thus made it in the deed of sale and induced the vendee to pay the price of 47,000 pesos. But before the contract was perfected, Ardante visited and examined the area by himself, and they does nothing to prevent such investigation. Lather or Ardante filed a suit for recovery of the excess payments for the said land because he was defrauded by Maria Chu. The Supreme Court held no contract for the purchase of real estate in reliance on the representation and statement of the vendor as to its character or value, but after he has visited and examined it himself and he has the means and opportunity of verifying such statement, not avoid a contract on the ground that such statement were false or exaggerated. So, Article 1341. A mere expression of an opinion does not signify fraud unless made by an expert and the other party has relied on the former's special knowledge. So, Article 1341 is all about expression of opinion. To constitute fraud, the misrepresentation must refer to facts and not opinions. Ordinarily, a mere expression of an opinion does not signify fraud. As a general rule, kapag human expression or just an opinion, it is not considered as fraudulent. Pero kung galing sa isang eksperto, ito ay may tuturing na fraud because an opinion from an expert is like a statement of facts, and if false, it may be considered as a fraud, giving rise to annulment. When the expert, however, was employed by the party who was misled, he cannot ask for annulment because he is chargeable with the acts and declaration of his employees. Under this provision, malalaman natin kung ang opinion ay fraud when it have these three requisites. First, it must be made by an expert. Second, the other contracting party has relied on the expert opinion. And lastly, the opinion turned out to be false or erroneous. So, para madali natin itong maintindihan, here is an example. Ben, a farmer, found a ring. He does not know anything about precious stones, and he sells the ring to Cardo, honestly believing and telling Cardo that it is a diamond ring. So in this case, there is no fraud even if it turned out that the ring is not a diamond, because his statement is merely an expression of an opinion. However, if Ben is an expert on precious stones and he sells the ring to Cardo saying, I believe that this is a diamond ring, and Cardo, knowing that Ben is an expert, relies on his special knowledge, then the contract is voidable on the ground of fraud, because Ben, being an expert, is making a misrepresentation of fact. He cannot escape liability by expressing it in the form of an opinion.
So let's proceed to Article 1342. Misrepresentation by a third person does not vitiate consent, unless such misrepresentation has created substantial mistake and the same is mutual. So generally, the misrepresentation of fraud employed by a third person does not vitiate consent, except when there is a connivance between the third person and one of the contracting parties, and when it has created substantial mistake on both parties. A third person has no connection with a contract. Consequently, a misrepresentation by him does not vitiate consent. A party should not be made to suffer for the imprudence of another in believing the fraud of a third person. The presumption is that both contracting parties are acting in good faith. However, if the misrepresentation has created substantial mistake and the same is mutual, that is, it affects both parties, the contract may be annulled but principally on the ground of mistake. If the misrepresentation has been employed by a third person in connivance with, or at least with knowledge of, the party benefited by the fraud, it is deemed to have been exercised by such party upon the other contracting party. It should be remembered that force or intimidation employed by a third person on one of the parties makes a contract voidable. The reason is because the consent is vitiated just the same. So let's have an example. B bought the land of S for 2,000 per square meter. The reasonable price of the lands in the same vicinity is 2,500 per square meter, but S sold it only for 2,000 per square meter because C had deceived him regarding its market value. So, in this case, the contract cannot be annulled unless it can be shown that the B was a party to the fraud. Another example is B wants to buy a parcel of land on which to build a house. S owns a land on which he wants to construct a commercial building. C tells B and S that the area where the land is located is a residential zone. B and S then enter into a contract of sale. It turns out that the area is a commercial zone. So, under the facts, the sale may be annulled because of substantial mistake which is mutual. Article 1343. Misrepresentation made in good faith is not fraudulent but may constitute error. If the misrepresentation is not intentional but made in good faith, it is considered a mere mistake or error. Fraud is definitely more serious than mistake. Hence, the party guilty of fraud is subject to greater liability. Example: S sold a ring to B. S honestly believed that what he sold to B was a diamond ring. It turned out that it was not a diamond ring. So the misrepresentation of B here is a mere mistake and the contract is voidable on that ground and not on the ground of fraud. Article 1344. In order that fraud may make a contract voidable, it should be serious and should not have been employed by both contracting parties. Incidental fraud only obliged the person employing it to pay damages. So Article 1344 distinguishes two kinds of fraud in the making of a contract. First is the causal fraud, which is a ground for the annulment of a contract, although it may also give rise to an action for damages, and the second is the incidental fraud, which only renders the party who employs it liable for damages because the fraud was not the principal inducement that led the other to give his consent. In order that causal fraud may be shed consent under this article, the following are the requisites. First, it should be serious. Second, it should not have been employed by both contracting parties. Third, it should not have been known by the other contracting party. The seriousness of the fraud is a question of fact depending on the circumstances. It does not mean its influence on the other contracting party, but its importance. The requirement that fraud should be serious excludes slight and usual deviations from the truth. Such deviations are frequently present, unfortunately, in transactions, especially for those taking place in fairs and markets. When fraud is employed by both parties, neither may ask for annulment as the fraud of one neutralizes that of the other. The contract is, therefore, considered valid. The rule is in accordance with the principle that he who comes to court must come with clean hands. Example, S sold to B a parcel of land. S told B that there were 3,000 coconut trees on the land, although he knew that there were only 1,000. B bought the land relying on the statement of S. The fraud here is serious and B can ask for the annulment of the contract. If there were only a difference of, say, 50 coconut trees, the fraud may not be serious or important enough to make the contract voidable, but B has a right to deduct from the contract price the amount representing the value of the 50 coconut trees. Article 1345. Simulation of a contract may be absolute or relative. The former takes place when the parties do not intend to be bound at all. The latter when the parties conceal their true agreement. And Article 1346, an absolutely simulated or fictitious contract is void. A relative simulation, when it does not prejudice a third person and is not intended for any purpose contrary to law, morals, good customs, public order, or public policy, binds the parties to their real agreement. So, simulation of a contract is the act of deliberately deceiving others by feigning or pretending by agreement. The appearance of a contract which is either non-existent or concealed. So, it is a mutual agreement ng parties pero hindi siya nag-e-express ng totoong intensyon ng parties. So, we have two kinds of simulation. First is the absolute simulation when the contract does not really exist and the parties do not intend to be bound at all. Example, D is indebted to C. Upon learning that C is going to enforce his credit, D pretended to sell his land to Fredo, his father-in-law. D did not receive a single centavo for the transaction and he continued in possession of the land as the contract was merely simulated or fictitious. So there is no contract of sale in this case as the parties do not intend to be bound at all. The next kind of simulation is the relative simulation. When the contract entered into by the parties is different from their true agreement. The parties are bound by the real agreement provided it does not prejudice a third person and is not intended for a purpose contrary to law, morals, good customs, public order, or public policy. Example, D and C entered into a contract of mortgage. But wanting to hide the mortgage, it was made to appear in the form of a deed of sale. So here, there are two acts involved, which is the ostensible or the apparent act, which is the contract of sale, and the concealed or hidden act, which is the contract of mortgage. As far as D and C are concerned, the contract entered into between them is a contract of mortgage. As to third person, the apparent contract, the contract of sale, is the one entered into. Consequently, if C is the mortgagee but is made to appear as the buyer and C sells the land to B, the latter will acquire ownership. D and C are stopped or barred from claiming that the real agreement entered into by them is a contract of mortgage.
Section 2 Objects of Contracts. Article 1347. All things which are not outside the commerce of men, including future things, may be the object of a contract. All rights which are not intransmissible may also be the object of contracts. Lahat ng bagay na wala sa labas ng commerce ng tao, kasama ng mga bagay sa hinaharap, ay maaaring bahagi sa kontrata. Lahat ng karapatan na hindi mapapasa ay maaaring bahagi sa kontrata. No contracts may enter into upon future inheritance except in cases expressly authorized by law. Walang kontratang maaring pumasok sa hinaharap na pamamana maliban na lang kung pahintulutan ito ng batas. All services, which are not contrary to law, morals, good customs, public order, or public policy may likewise be the object of a contract. Lahat ng serbisyo na hindi labag sa batas, moralidad, mabuting kaugalian, pampublikong kaayusan, o pampublikong panuntunan ay maaaring maging katulad ng bagay sa kontrata. Article 1348. Impossible things or services cannot be the object of contracts. Ang mga bagay o serbisyo na imposible ay hindi maaaring maging bahagi ng kontrata. Concept or kinds of contracts. The object of a contract is its subject matter. It can be a thing, right, or services arising from a contract. Requisites of things or services as object of contract. In order that the things may be the object of contract, the following requisites must be present. First, the things or service must be within the commerce of man, that is, it can legally be the subject of the commercial transaction. In other words, it should be susceptible of appropriation and transmissible from one person to another. Second, it must not be impossible legally or physically. The object should be licit. In other words, it should not be contrary to law, morals, good customs, public order, or public policy. Third, it must not be in existence or capable of coming into existence. The object should be real and possible. In other words, it should exist at the moment at the celebration of the contract, or at least it can exist subsequently. Last, it must be determinate or determinable without need of a new contract between the parties. It should be possible of determination as to its kind. Rights as object of contract. First, outside the commerce of man, including the future things. Second, impossible physically or legally. Third, determinable things. 4. Future things or rights. 5. Intransmissible rights. Definition of future inheritance. Future inheritance is any property or right not in existence or capable of determination at the time of the contract that a person may inherit in the future. Ito yung kayamanan, ari-arian, ano pa man ng isang tao na ipamamana o ipapangalan sa iba. Validity of contracts upon the future inheritance. In case of marriage settlements, future inheritance may be the object of donation. Anumang ari-arian na nabili ng mag-asawa habang may buwis ang kanilang kasal, at kahit hiwalay na sila, ay pantay pa rin ang kanilang pagkahatian. In case of partition of property, inter vivos made by the deceased himself as long as no legitimate is impaired. Kinds of impossibility. First, because of the nature of the transaction or because of the law. Second, absolute. Third, relative. Fourth, legal. Example of the impossible things. Before I can give you 1 million pesos, you must fly like an eagle without any device. Article 1349. The object of every contract must be determinate as to its kind. The fact that the quantity is not determinate shall not be an obstacle to the existence of the contract, provided it is possible to determine the same, without the need of a new contract between the parties. Ang bagay sa bawat kontrata ay dapat tiyak sa kanyang uri. Ang katotohanan na tila hindi tiyak ay hindi maaaring maging hadlang sa pagkakaroon ng kontrata, maliban na ito'y maaaring tiyak na bilang na hindi kinakailangan pa ng panibagong kontrata sa pagitan ng mga partido. Determinate or specific thing, particularly or physically segregated others of the same class. Example, the t-shirt Levi's I am wearing. The Toyota car with the plate number AST 143 2016. Generic or indeterminate thing. A thing cannot be specifically determined from things of the same class. Example, a brand new t-shirt. A 2016 Toyota car.
Article 1350. In onerous contract, the cause is understood to be for each contracting party the prestation of promise of a thing or service with the other. In remuneratory ones, the service or benefit which is remunerated, and in contracts of pure beneficence, the mere liberality of the benefactor. First of all, what is cause? Cause or causa is the essential or more proximate purpose or reason which is the contracting parties have in view at the time of entering into the contract. Sa madaling salita, cause is the reason why we assume the obligation that to explain and justify into a contract. So now, let's distinguish the cause from the object. In bilateral or reciprocal contract, like purchase and sale, the cause for one is the object matter, or object for the other, and vice versa. Hence, the distinction is only a matter of viewpoint. So, let's have an example. A sells a watch to B for 2,000 pesos. As far as A concerned, the subject and the subject matter or the object is the watch and the cost is the price. And regards to B, the subject matter is the price and the cost is the watch. However, this distinction, the cost for A is the delivery for the price and for B is the delivery for the watch. But both A and B is the subject matter of the transaction is the watch. Now let's move on to the classification of contracts according to cost. First, onerous contracts. One of the cause of which for each contracting party is the prestation or promise of a thing or service by the other. So, in onerous contract, they are reciprocally obligated to each other. So, yung cost and consideration in onerous contract is the prestation or a promise of a thing or service with the other. Kaya tayo pumapasok sa isang contract kasi may promise yung other party sa atin. That's why we consider it to enter into a contract. So the best example for onerous contract is a contract of sale. The next one is the remuneratory or remunerative contract. One, the cost of which is the service or benefit which is remunerated. So if the contract is remunerative, the cost of contract is a service or benefit which is remunerated. It is to reward the service that has been previously rendered. Lastly, the gratuitous contract. One of the costs of which is the mere liberality of the benefactor or the giver. So, if the contract is a pure beneficence, the mere liberality of the benefactor, it is a voluntary or bukal sa loob natin to give. The best example of this is the donation. Article 1351. The particular motives of the parties in entering into a contract are different from the cause thereof. Motive is a purely personal or private reason which a party has in entering into a contract. It is different from the cause of contract. Cause of contract different from the motive because cause of contract is the objective and juridical reason for the establishment of a contract and is always the same, while motive is a psychological or personal purpose of the party. In getting the object differs of each person, motive or illegal motive does not affect the validity of the contract. For example, T buys a knife worth of 2,000 to K to kill P. The cost of contract to T is the knife and the money for K. The motive of T is to kill P. The transaction here is valid or the cost, but the motive is illegal because the motive of T is to kill P. However, the motive does not affect the validity of the contract. Let's proceed to distinguish cause from the motive. As contradistinguished from consideration or cause, motive has been defined as a condition of mind which incite to action, but also include the inference as the existence of such condition from an external fact of a nature to produce such a condition. Let's now have the difference between the cause and motive. First, cause is the immediate or direct reason, while motive is the remote or indirect reason. Next is the cause is always known to the other contracting party, while motive may be unknown. The third, cause is an essential element of a contract, while motive is not. Lastly, the illegality of the cause affects the validity of the contract, while the illegality of the one's motive does not render the contract void. And now let's proceed to Article 1352. Contract without cause or without unlawful cause produce no effect whatever the cause is unlawful. If it is a contrary to law, morals, good customs, public order, or public policy. According to Article 1352, without a cause, the contract is void, so it produces no effect. And also, the cause is illegal, the contract is also void. Requisite of cause. First, it must be exist at the time of the contract is entered into. So the cause must be present kasi if not, magiging kulang ang essential requisite ng contract which is consent, object, and cause. The next is requisite is the cause must be true or real. And the last one is it must be lawful. Effect of the absence of cause. Absence or want of cause means that there is a total lack of any valid consideration of the contract. Effect of illegality of cause. Illegality of cause implies that there is a cause but the same is unlawful or illegal. So, if the contract with a lawful cause are void and none, example, a promise to a marriage based on carnal connection.
Article 1353. The statement of a false cause in contracts shall render them void if it should not be proved that they were founded upon another cause which is true and lawful. Effect of falsity of cause is meant that a contract states a valid consideration, but such statement is not true. A false cause may be erroneous or simulated. The first always renders a contract void. If the cause is false, the contract is rendered void because the same actually does not exist. The second does not always produce this effect, because it may happen that the hidden but true cause is sufficient to support the contract. If the parties can show that there is another cause, and that said cause is true and lawful, then the parties shall be bound by their true agreement. For example, D promised to give C 1,000 pesos as payment for past services, allegedly rendered by C, which in truth and in fact have not been rendered, or for a carabao, which unknown to D is already dead. Here, the cost for D, the service remunerated, or the promise of C to sell the carabao is erroneous, as it is based upon facts believed to be existing, but really inexistent. Article 1354. Although the cause is not stated in the contract, it is presumed that it exists and is lawful, unless the debtor proves contrary. It is not necessary that a cause be expressly stated in a contract. The presumption is that a cause exists and is lawful unless the debtor proves the contrary. This presumption is in accord with the natural order of things. Ordinarily, a person will not part with his property unless there is a consideration. For example, M issued in favor of a promissory note which recites, 30 days after date, I promise to pay P or order the amount of 10,000 pesos. Signed, M. Although the promissory note does not mention the consideration, the law presumes that M must have received a consideration for the debt, and the same is lawful. If M claims otherwise, then he has the burden to prove his allegation. Article 1355. Except in cases specified by law, lesion or inadequacy of cause shall not invalidate a contract unless there has been fraud, mistake, or undue influence. Lesion, as defined, is any damage caused by the fact that a price is unjust or inadequate. It is the injuries suffered in consequence of inequality of situation by one party who does not receive the full equivalent for what he gives in commutative contract, like a sale. Effect of lesion or inadequacy of cause. A general rule: lesion or inadequacy of cause does not itself invalidate a contract. A person who willingly enters into a contract will be held bound by its terms, though the exchange of benefits may seem to be inequitable or unfair to him. The law assumes that the parties themselves remain the best judges of how much their bargain is worth. But there are exceptions in the effects of lesion or inadequacy. Lesion will invalidate a contract when there has been fraud, mistake, or undue influence, and in any cases specified by law.